Summer is now unofficially over and the 2012 campaign season is well underway. Here to talk a little bit about the elections, we have Secretary of State Mark Ritchie. Thanks so much for joining us today.
Thank you for having me back on your show.
Mr. Secretary of State, there's so much going on, a lot of different tentacles out there concerning this year's election. I want to begin with the recent Supreme Court decision on changing the titles of 2 constitutional amendments. Your statement after that decision was essentially to praise the High Court on its prompt decision and then to ask voters to really study the issues and the candidates. So first, I want to ask you what your immediate reaction was when their decision came down.
Well, there was a dispute between the legislature of 1981, which set the law that said the Secretary of State shall provide the titles for a constitutional amendment. That was affirming a 1919 law. So for the past 100 years, the legislature had one set of rules, and the current legislature didn't agree with those rules. So the Supreme Court said, we will affirm the current legislature's decision that they no longer want that law to be in place. And essentially the Supreme Court overthrew that law or changed that law. And they did it just in time because we have to prepare ballots, mail them out to our soldiers and others serving overseas, and they cannot be late, because if they get them too late, they can't send them back, and so they can't be part of the election. And so the fact that they got it done right on time was perfect for us, because we have a lot of work to do to make sure everybody who has the right to vote has the opportunity to vote.
Were you surprised at all by their decision?
Well, you know, it was a kind of a partisan matter. It has had a lot of partisan energy to it. I don't think I was very surprised how the court split on a partisan basis. But it didn't matter. The legislature having an argument with itself can only be settled at the level of the Supreme Court. That's the only place. So the law said the Secretary of State shall provide the titles for constitutional amendments. Passed in 1919, affirmed in 1981. If the current legislature disagreed with that legislature, that can only be settled at the level of the Minnesota Supreme Court. And my issue is making sure we got the decision on time, because our job is getting the ballots out so everybody can vote, but especially people who are out fighting to defend democracy, making sure they have a right to vote and the opportunity to vote.
The second part of this is asking voters to really study the issues. Are you concerned at all that maybe...
Yes, actually, the Supreme Court made 2 rulings. So one on titles was a tiny one. I don't know,
then
20
pages. Then there was the voter ID language as well.
There was a 120-page ruling, which was much more important because early on in our state's history, we decided to print in every newspaper what's actually being proposed to go into the Constitution, along with this very important document that the Attorney General provides called the Statement of Purpose and Effect, summarizing what is this language intended to do and what will the effect be. Often it discussed the taxpayer costs, because taxpayers are really concerned about the high cost of things. So at some point in our history, we had that as our procedure, but we also decided to never print the actual language that was going into our state's highest law, our Constitution, on the ballot. So until the early part of I think the 1970s, 1980s, everyone could read what was proposed to go into the Constitution and make their own decisions about that. At some point, because of budget and a lot of other considerations, we stopped printing what's being proposed to go into the ballot. And then it became a lot more politicized what was going to go on to the ballot, because it was clear that you could decide to correctly or incorrectly describe. You could decide to completely or in a very limited way describe. And so in a number of states, this has been a subject of great controversy. Courts have ruled that it's not okay to be inaccurate or unfair. The Missouri court, for example, on a very similar set of cases. So the citizens of the state, represented by a number of organizations, raised questions about the accuracy and the completeness or the comprehensiveness of the proposed ballot statement. The legislature said out loud, we think it's fine. The Supreme Court ruled, and with some very, very strong dissents, but they ruled that the legislature can put basically anything they want to on it, but not the actual language being proposed to go into the Constitution. And so we believe that it's important for the citizens to know what they're voting on, and we no longer put this in the newspapers like we used to. And so the only thing that's left is for citizens to take it upon themselves and for the media, out of their civic duty, their civic responsibility, to resume that role that they used to have. I mean, I think it would be a very good idea to return to making sure that every citizen had the chance to read in the newspaper. But today, we have websites.
And it
we
is
have
on your
different
website,
opportunity.
correct?
Well, and it's also on a number of newspapers' websites. We are trying to urge people to go look the legislature itself. It's very interesting what the legislature has on its website as its overview and summary of the proposed constitutional elections is quite good and quite complete and very comprehensive. And so looking at the actual language, looking at how the legislature summarized it, can help voters understand. Because the main thing is that we, in the past, always limited constitutional amendments to one very distinct item. Now they have many. For example, this constitutional amendment on elections converts Election Day registration over to a new system called provisional ballots, so that affects about 540,000 people who no longer will be able to register and vote right there on Election Day in the polling place. They'll have to submit provisional ballots. It affects about 250,000 military voters and township voters who will have to change their system, and then it affects others as well. So summarizing a great big complete proposed amendment to the Constitution needs the kind of time and attention that citizens will have to devote so that they know what are all the ramifications. There have been no real serious attempts to publicize the cost, but also the costs are very important because they tend to fall right on those local taxpayers in the townships and towns. So my urging is for the media to put up the actual language, you know, and whatever information is available, and then for the citizens to make sure they read the actual language. Because once something's in a constitution, it's not something that the legislature can fix or tweet or correct a mistake, or some governor could fix. No. Even if the governor and legislature agree something is horribly wrong or needs to be fixed, you can't change the Constitution without going back through the constitutional amendment process to the citizens. So what you put in the Constitution is kind of forever until you go through the process.
And to that point, my last question for you concerning the amendments would be, some members of both parties have said that perhaps there needs to be a supermajority vote to get a constitutional amendment to the voters. What do you think of this idea?
Well, I know how we got the current unusual system of this very low bar. When Democrats and Republicans came together 152 years ago to write a constitution, they got into a big fight. They split into two. The Democratic Party wanted to take away the right to vote of freed African American men. So the Republican Party wanted to affirm the right to vote of freed African American men. They battled. They couldn't agree. The Republicans agreed to go along with the Democrats to take away the right to vote to freed African American men, but they got as their concession a very, very low bar for amending the Constitution, and then spent 10 years to restore the right of freed African American men to vote. So from the founding of the state, we've had this extremely low bar, unusual in the country. And most states have said, you got to pass it through 2 legislative sessions, you got to have a supermajority before it happens. At the federal level, it's 2/3 of the Congress, and I think 3/4 of the states. So I do think we have a very unusual story, which you can understand from a historical perspective, but I do think that the legislators who year after year propose a higher standard are thinking more like the other states, you know, across the nation. And I think the legislature probably will take some kind of look at this. And of course, that would take a change in the Constitution as well.
Okay, Mr. Secretary of State, thank you for joining us today.
Thank you so much.